English legal shorthand words per minute. Ready, start. From the above, it is seen that Section 36 of the ID Act governs representation of parties in dispute, allows workers to be represented by members of registered trade union and employers by an officer of employers of association. Stop. A key restriction is in section 36 bracket 3, which imposes a complete embargo on representation of parties through advocates/legal practitioners before the conciliation officer and the labor court/tribunals. Stop. However, section 36 bracket 4 of ID Act permits representation through a legal practitioner before labor courts and tribunals with the consent of other parties and the leave of the court. Attention is drawn to the decision of the Supreme Court in the case of Pradeep Port Trust in bracket Supra, wherein the court has exhaustively dealt with the scope of sections 36 bracket 3 and 36 bracket 4 of ID Act in paragraph numbers 20 to 24 of the said decision, which reads as under. The Solicitor General contends that and in section 36 bracket 4 should be read as or in which case refusal to consent by a party would not be decisive in the matter. Stop. The tribunal will then be able to decide in each case by exercising its judicial discretion whether leave in a given case should be given to a party to be represented by a lawyer notwithstanding the objection of the other party. Stop. It is pointed out by the Solicitor General that great hardship will be caused to public corporations if the union is given a carte blanche to finally decide about the matter of representation by refusing to accord its consent to representation of the employer through a legal practitioner. Stop. It is pointed out that public corporations, and even government running a transport organization like the state transport, cannot be expected to be members of any employers association. Stop. In their case, section 36 bracket 2 will be of no avail. Stop. To deny them legal representation would be tantamount to denial of reasonable opportunity to represent their cases before the tribunal. Stop. It is submitted that since such injustice or hardship cannot be intended by law, the final word with regard to representation by legal practitioners before the tribunal should rest with the tribunal, and this will be effectively implemented if the word and in section 36 bracket 4 is read as or. Stop. This, it is said, will also achieve the object of the act in having a fair adjudication of disputes. We have given anxious consideration to the above submission. Stop. It is true that and in a particular context and in view of the object and purpose of a particular legislation may be read as or to give effect to the intent of the legislature. Stop. However, having regard to the history of the present legislation, recognition by law of the unequal strength of the parties in adjudication proceedings before a tribunal, intention of the law being to discourage representation by legal practitioners as such, and the need for expeditious disposal of cases, we are unable to hold that and in section 36 bracket 4 can be read as or. Stop.